All rise. Oh yay, oh yay, oh yay. The Honorable Court of Appeals for the 10th District of Texas is now in session. God save the Constitution and this honorable court.
You may be seated. I want to welcome everyone to the afternoon session of the 10th Court of Appeals holding oral arguments in the city of Bryan on the Blinn campus. We've got one case on the docket this afternoon. I'll ask for announcements in a minute. I will say that check your cell phones, make sure they're in the off or silent position. Basically, if you want to know something about the court, administration, that kind of thing, log into YouTube on the court's channel. I went through extensive recognition of folks this morning, and in the interest of time, I'm not going to repeat that. We had a fairly extensive Q&A session that answered a lot of questions about the court, and there's some of that Q and A that is before, the oral argument, then there's some after, then there'll be a pause. And then at 12 o'clock, there's another 30 or 40 minutes of Q and A. So I encourage you to go to that morning session, what's pre-recorded on the YouTube channel, and you can see all that. If you have one of the pamphlets that was distributed, look like that. If it's not in your chair now, Robert will be able to point you to one if you don't already have one. There are instructions of where the court's YouTube channel is, and then there's also case mail citation in there where you can go and log on to case mail to follow what happens in this or any other court pending, or any other case pending at any court of appeals in the state of Texas. You can follow it by signing up for case mail for that particular case. Anything else before we start? Anything, gentlemen? Okay. Court that calls Brown versus State 1023-00153 CR. Announcements of council, please.
Good afternoon, Kimberly Lucas on behalf of Mr. Brown.
Thank you, counsel.
State of Texas is present ready. Sterling Harmon with the McLennan County Criminal District Attorney's Office appearing for the state.
Thank you, counsel. The way we do this for you all that did not see this morning's deal is we let the attorneys talk to you all for 3 minutes before they turn to us and give their oral arguments to the court. This is done so that it can put the facts or the procedure of the case in context that y'all can then follow their legal arguments that are being made to us. And with that, I will recognize Attorney Lucas to present her 3 minutes on behalf of Mr. Brown. And you may proceed when ready, if you'll pull that microphone over to you so that everybody can hear you.
I don't know. Everyone hear me now? Now I can hear me now.
My name is Kimberly Lucas, and I'm here on behalf of Mr. Brown. The facts surrounding the case that we're here today are fairly simple. My client, Mr. Brown, was a passenger in a vehicle that was traveling on the interstate on January 30th, 2020. When the vehicle was stopped by Officer Bose for some traffic violations, the vehicle pulled off to the side of the road. The driver was asked to step out of the vehicle and come back, and she sat in the front of the police officer's vehicle. During that time, the officer asked the driver various questions as he was writing out the warning citations. During that time, my client was the back seat right passenger in the vehicle, and there were 3 other occupants with him, which meant there were 5 total people in the car at the time of the stop. As the officer is writing out the citations, he gets out of the vehicle, reapproaches the car, and only talks to the occupants of the vehicle. At that time, he tells them that he smelled the odor of marijuana and he demands that everybody identify themselves in the vehicle. My client questions, why do I have to identify myself? I'm just sitting in this car. There's nothing illegal going on. I'm not doing anything. To which the officer repeatedly, over and over, for various minutes, and back and forth with my client, explains that the officer smelled marijuana and therefore everyone is detained and everyone must identify themselves. After minutes of this going on, my client gives a pseudonym, a name that he's written books under. The officer takes that down, goes back to his vehicle, further into the stop, realizes that this is actually not the legal name that's on my client's identification, and my client is arrested for failed to ID, giving a fictitious name. The crux of our argument today is that my client was not actually detained as required by the law at the time he gave that name. That was not his name on his identification. And our argument is that just because the vehicle is stopped and the occupants are detained, is not detained for all purposes. The officer searched the vehicle, nothing illegal was found in the vehicle, and my client was arrested that evening. He was sentenced to a $2,000 fine and no time in jail. And that is our first issue on appeal. The second issue goes to something that the judge ordered later, stating that if my client could not pay his fine within the reasonable amount of time, that he would not have a right to a hearing as required by law, and that he would go straight to jail. Thank you.
Now if you'll pull that mic back over to you. And I'll get the clock reset for your oral argument time. And you may proceed when ready.
May it please the court.
Work a little harder to get that mic in line with you there.
May it please the court.
Perfect, thank you.
And Mr. Sterling. This is a fairly simple case on its face because we're dealing with the Fourth Amendment stop of a vehicle. I would point out that the argument that the state makes that the Blinn case overrides the St. George case, which we rely heavily upon in our brief, is kind of misguided. The St. George case first came to the Texas Appellate Court and was decided that when a vehicle is stopped, the occupants in the vehicle have an interaction with the police and it's only a consensual encounter. The Blinn case decided by the US Supreme Court said that when a vehicle is stopped, all the occupants are detained. Our argument is that both of these can be valid at the same time. Blinn is specifically talking about the detention and the movement of people inside the vehicle. And so if there is a valid reason for the stop, all the occupants in the vehicle are detained. And that case specifically goes to whether or not an occupant of a vehicle has a right to question the validity of the stop, because it had been questionable up to that point. And that's all that case talks about. In St. George, after the appellate court ruled on it, it ended up going up to the Texas Court of Criminal Appeals. The Court of Criminal Appeals opinion came out after Blinn, and it doesn't mention that because it's talking about an entirely different portion of the stop. In the St. George case, they're talking about whether or not an occupant in a vehicle is required to answer the questions of the officer. And that's why it's akin to the case that we have here today. My client, Mr. Brown, was not the driver of the vehicle, he was an occupant, a mere passenger. And so what's required under St. John is that even though the physical person is detained, there has to be reasonable suspicion as to each individual occupant for the officer to continue the stop or to engage in forceful questioning of those occupants. This court held earlier this year in Scarborough that reasonable suspicion is articulable facts that when combined with rational inferences from those facts leads an officer to have a reasonable belief that the defendant is engaged in criminal activity. So what we have is a vehicle that's stopped. And there's a reason that the officer can talk to and demand identification from the driver because they're the ones that violated the law with the traffic violation. But then we need to move to the next step. The officer is allowed to go up to the window of the vehicle and ask everyone to identify themselves. But St. George makes it clear that they cannot coerce a person to identify themselves unless the officer has reasonable suspicion.
Why is the odor of marijuana not reasonable suspicion?
That gets to my next point, which is also what the state argued. The timing of this case is very relevant to my argument. This happened in 2020. In 2019, in June, Texas adopted the Hemp Act that changed kind of how marijuana was handled in the state of Texas. After that time, there is a legal reason that someone may smell like marijuana. Cases all over the country and the state have held that the smells are identical because they come from the same plant. In January of 2020, Delta 8 was also legal at that time and was very widely popular. What I'm arguing today is that this court take a look at whether, after the passage of the hemp law, the smell of marijuana / hemp is enough on its own. I know that all the cases that the state has quoted are pre-hemp law, and so I agree. Prior to that change in the law, it was settled law. If it smelled like marijuana, an officer had probable cause to search a person or vehicle. That was well settled. But this isn't well settled because we have this new introduction that gives a potential legal reason for someone to smell like this. I would ask the court, look at this very similarly to the smell of alcohol. There is a legal reason why someone may smell like alcohol. And so an officer cannot just stop at the smell of alcohol. He has to look to the totality of the circumstances. That may be one of the factors, but the smell of alcohol alone is not enough. We don't put the burden on the civilian to have to prove their innocence. We put the burden on the officer of the state to show why this is most likely not a legal situation. Recently, this issue has been brought up in multiple appellate courts across the state because it's not well settled area of law. It's not settled at all. And to my knowledge, the state criminal court of appeals has not taken up this particular issue. There is a court case of Isaac versus the state of Texas. And it's out of the Court of Criminal Appeals from San Antonio, and it's from August of last year. And they take the smell of marijuana and they apply a totality of the circumstances application. They admit that the smell of marijuana alone may not be enough to get us where it used to get us. But in light of the other circumstances, the officer could have a reasonable suspicion. So what I'm asking this court to do is to look at the facts in this case. Officer Bose testified the only reason that he was detaining and questioning the occupants of the vehicle is because he claimed he smelled marijuana when he approached the vehicle. And he thought that that gave him probable cause to search everyone. And he went back and forced my client under duress to provide some sort of name. I would argue at no time up to the point my client gave that pseudonym that he was actually under a passive consensual encounter into a reasonable suspicion required to identify himself.
So if I'm understanding your argument correctly, it is based solely upon the Hemp Act making the encounter with the passenger nothing more than a consensual
Encounter.
encounter. But that if the Hemp Act did not change that, then your client's argument is in effect goes away.
Most likely, yes.
Okay,
Because it has been very well settled that if an officer smelled marijuana, he had the right to search the occupants in the vehicle. But there was never a legal reason for anyone to smell like that before. So that's why he came into the alcohol, because you can legally smell like alcohol, but there has to be more than that. The other thing to keep in mind is that the statute 38.02, the failure to identify statute, has changed over the years since it was first adopted. The original enactment of it was actually held unconstitutional by Brown versus State, and it's gone through different changes over the years. I think it's important to point out that most recently, in September of 2023, they added an addition to that law that now requires a driver to provide identification if required, which to me reiterates the fact that there's not a requirement for a passenger to identify themselves, which is also in line with St. George, unless it moves beyond that. To which my argument is that the smell alone cannot be enough. In the Isaac case I quoted earlier, the officer also saw marijuana blunts in the vehicle, along with the way the driver, it was a driver in that case, but the way that he was acting and the smell. So the court in that case said, as part of the totality of the circumstances, we believe that the smell can be used in furtherance of these cases. But they didn't particularly say the smell alone would be enough. They just said that it can be a factor in the totality. In this case, there are no other totality circumstances other than my client being in a car. And once he refused to identify himself, the officer insisted, which we argued he had the right to do. So if that is accurate, and my client was not actually detained for the purposes past a consensual encounter, where he'd have to identify himself. And he was not a fugitive at the time, and had nothing illegal on him. Moving on to my second argument, goes to the court order. For some reason in this case, after my client was found guilty, and he was ordered by the jury to only pay a fine, the judge talked to my client on the record about the time frame that he would have to pay that fine. And the judge signed paperwork saying that my client had waived his right to a hearing, which never took place. There's no indication of that on the record. And then the judge also told my client that if he did not pay on time, he would go straight to jail. That flies in the face of my client's ability to actually have a hearing as to whether or not he was indigent or had an ability to pay the fine. I know the state argues that this isn't right yet, but I would contend that if we wait until my client can't pay and he's arrested and he's in jail, that by the time we got through the court system, my client would have already suffered all of the harm of not being afforded a hearing. It's very likely that this will arise because my client was indigent at the time of trial. I'm still court appointed to represent him through this appeal, and it's very likely he'll continue to be indigent and that this will arise. So if we have the court overstepping its authority and saying that my client's already not allowed to have a legal proceeding that he is allowed to have, then my client would bear the brunt of all of that harm.
I do have a question.
Yes.
With regard to the hemp law, you mentioned that you distinguished another case where you said that there was a blunt in the car. And obviously it smelled the same as marijuana or burning hemp, whatever the case may be.
Right.
I guess my question would be, a lot of times in cases you see where they find residue from ground up marijuana, on the car seats or on the floorboard. Sometimes they see a joint in this ashtray or things like that.
Yeah.
I want to know if your argument carries as far as, can you distinguish hemp visibly from marijuana? I mean, if officers in the future are going to be pulling someone over and they smell this hemp, and it smells like marijuana, and they see a blunt. Now, I realize they may not be driving around, smoking hemp, but, I mean, but
Right.
we have, if it's legal, I mean, they could do it if they wanted to, I guess. I guess my question is, do you think that that's not gonna add to the totality of circumstances? If they see visible, physical evidence, residue?
I think we can distinguish that because I think typically hemp is not used in the blunt form. And that's not how, people would go around using it. And so when you don't have that visible evidence, that would also suggest that it's an illegal substance, that the smell alone would be not enough. But if the officer did see some physical form of evidence, that would be what would get him into that totality, the smell, plus it appears visibly to be an illegal substance, that would get him farther into that. Okay, now we have a reason to start questioning people and taking them out of the car.
Well, doesn't hemp always appear to be an illegal substance? I mean, you can't visibly tell the difference between hemp and marijuana.
That's my understanding, is you can't visibly tell the difference.
So I guess
Go by the use.
my question is, I mean, if someone's got some ground up hemp and they've got a joint of hemp, I mean, I'm wondering, are you saying that that's all going to be excluded from the totality? You're not.
I don't. One of the cases I read kind of talked about this issue, also said that an officer kind of has the ability for his reasonableness to be wrong. So I think that the more factors that an officer could point to as to explain why he believed it to be illegal marijuana, would be going back to that reasonableness of the officer at that time. Our officer in this case was an interdiction officer, and so all he did was traffic stops to stop drug traffic on the interstate. And he admitted on the stand that at least a quarter of his stops he smelled marijuana. And then he admitted that in the entire month of January, because the stop had happened in January, on the car audio at the stop, he was complaining to the other officers, "Shh, it hasn't been my month." And when I asked him to explain that, he said that he had not had any drug busts the entire month. And I think that is very important because he's claiming that he's smelling marijuana and that's going for him to have a reason to search people and delay the stop, have them on the side of the road for hours. And he's not even finding anything. That goes to his own subjective reasoning. When it's only the odor of marijuana, how reasonable is it to search everyone and pull everyone out?
I have a question, something I may have missed in the details. Was this the burning odor or just the odor of the physical plant itself?
He just said the odor of marijuana. It wasn't delineated at that time as to what, and nothing was found.
Because there are times you have a bale of marijuana in the back and they can smell it, and it's not on fire, it's not burning at all.
Right. And I would assume they have different smells, but that wasn't delineated in fact here.
Thank you.
The Supreme Court case that has recently held that when you stop a car, all passengers are detained for
Yes.
constitutional purposes. Why does that not give the officer the authority on that legal issue alone to then proceed to identify or require the identification of each of the passengers if they are constitutionally detained and the officer asks for their identification?
It would appear at a minimum at this point, through that St. George case, the state of Texas is actually giving occupants more rights than would be required by the Constitution. So they are detained and they can't move. But our state is also giving them the opportunity to not have to answer questions until an officer can identify a reason to question them. And so it kind of takes that Brennan opinion and gives occupants a little bit more protections, which the state is allowed to do. They're not taking away the rights under Brennan because an occupant still also has the right to argue that the initial traffic stop was not valid. So it affords them both rights. Thank you very much.
Thank you, Counsel. Counsel, you've got 3 minutes to address the audience.
Thank you, Judge. How many people were here this morning, heard some of the spiel this morning? And maybe a third of you. Well, I don't want to go through all of that again, but I do want to thank Blinn administration for inviting the court and the parties to put on this exhibition for you today. I'm Sterling Harmon with the Clinton County DA's office in Waco. So I'm also thanking you on behalf of my boss, Mr. Josh Cheatons. The theme of today's arguments seems to be encounters between individuals and police officers. This is my second argument today. Both of those involve motorists. So maybe in your classes or what have you, this will be fodder for you to discuss those kinds of issues, how they affect us socially, culturally, and the interplay between the law and individual rights and that sort of thing. I would caution you that not to put too much emphasis on the details of any particular case, but hopefully what we're presenting here will give you some food for thought. Ms. Lucas, I think, set out the facts of the case fairly well, and I will be addressing some of those. But I would like to also mention that even though we call this an argument, really it's more of a discussion amongst lawyers and trying to convince. It's not so much an argument as that kind of a clarifying discussion. Ms. Lucas and I were actually on staff together at the DA's office back in the day, and visiting with her and her husband earlier, kind of old home week. So even though it's an adversarial situation, I certainly don't consider us to be adversaries. I'm on public salary, I can't afford this.
You may proceed when ready.
May it please the court, counsel? The sole issue in regard to, the actual criminal law aspect of this is a single issue in regard to the sufficiency of evidence. It is not a claim in regard to, suppression of evidence under either the Fourth Amendment of the United States Constitution or under the due course of law provisions of the Texas Constitution. So the standard that we're looking at in regard to sufficiency of evidence is the old reliable, Jackson versus Virginia standard, which requires the reviewing court to, look at all of the evidence that was adduced at trial, whether, properly or improperly admitted. As I say, this is not a suppression issue, so the facts that go towards whether or not the jury, a reasonable jury, could have determined the essential elements of the offense of failure to identify from that evidence, that considers all of that evidence. And that includes the testimony of this officer as to why he executed the traffic stop and why he prolonged it, based on his smelling the odor of marijuana. So that the application of that simple standard to these simple case facts should determine that the evidence was sufficient, and thus the appellant must fail on this appeal. The reliance on the case law of St. George and the Blinn case, again, those go to suppression type issues, which are not before the court.
Doesn't the issue turn upon whether or not Mr. Brown was detained for purposes of having to give his identification? And so it has to be sufficient in that regard, that there has to be evidence that he has been detained before he is obligated to give a proper name.
Yeah, well, as I understand where we're headed with that question is whether the Blinn opinion or the St. George opinion holds sway. And I would argue that under the Blinn standard, once that vehicle has been stopped and the officer enunciated in his testimony as to why he stopped that vehicle on the basis of traffic violations, and under the Blinn standard, that detains the entire car and everyone in it under that Fourth Amendment standard as enunciated by the Supreme Court in Blinn. If we're looking at the St. George standard, and it very well may be that under the Texas Constitution, the Texas Constitution affords more rights to these motorists in those situations than does the U.S. Constitution under the Fourth Amendment. But again, that is not before the court, before I proceed. But even under St. George, we have a situation where the officer on approaching this vehicle smells marijuana, and that's what he enunciates. I would, and Ms. Lucas touched on this somewhat, alludes to the comparison with the DWI stop. The odor of alcohol alone does not justify an arrest for driving while intoxicated, but it is one of those factors which would merit further investigation by the officer. And those, y'all have dealt with DWI cases ad nauseum throughout your career. You understand what those factors are. Red, glassy, bloodshot eyes, the unstable stance and gait, the erratic driving behaviors, et cetera, et cetera. All those factors that would conduce to show a loss of normal use of physical and mental faculties. That can be analogized to a situation where an officer smells what he knows is, from his experience, is the odor of marijuana. That very well may not be marijuana, it could be hemp, but it does provide the probable cause for him to further the investigation. The public policy, of course, in dealing with people at roadside in the middle of the night where you have a reason to be investigating whether or not an offense has, is, or will be committed, is that for officer safety purposes, the officer would really like to know if this is a fugitive from justice. Do they have a criminal record? What kind of criminal record do they have? And for that reason, the public policy issue alone is that if an officer asks you to identify yourself, and there's a reason for him to be interacting with you to ask that, then you need to give him that information.
So your argument is that the United States Supreme Court case makes this no longer the equivalent of a consensual encounter, and therefore the officer is entitled to know who he is dealing with.
I think entitled is a little bit too strong a word to use with law enforcement, but authorized, I would say yes. And that under a federal Fourth Amendment analysis. As I say, the Court of Criminal Appeals may very well determine that there is a greater liberty interest in Texas motorists under the Texas Constitution. But I would argue that even under the St. George standard, that once the officer detected marijuana during his initial approach to the vehicle, he had the reasonable suspicion at least to go beyond what the original purpose of that traffic stop is. He's now smelled marijuana. That is a different strike of cat. And he had the authority to continue investigating that. And part of that investigation is for officer safety purposes, if nothing else, to identify who these people were that he was dealing with. He was outnumbered 5-1 at that point. It was the middle of the night. So there's a reason for that to happen.
So you're saying that once he smelled marijuana, he had the legal authority to go ahead and determine, even if we accept the hemp argument, that there may be a legal reason that this person smells like hemp, or the car smells like hemp,
Yes,
that the police officer at least has the authority to investigate whether that odor is legal or illegal.
yes. And the ultimate determination of that, well, I would analogize that to other controlled substance cases. Cool story from when I was prosecuting in Stephenville. We had a defendant pulled over. He had a vial of a crystalline substance in his dashboard that had the appearance of methamphetamine. And it field tested positive for methamphetamine. So he's arrested for possession of methamphetamine. Lo and behold, he had a heart condition. He hadn't had any symptoms, but he had nitroglycerin tablets that had dissolved in that little vial over the years. The officer was well within his authority to investigate, and from what he saw, the appearance of what appeared to be methamphetamine, it positively field tested for methamphetamine, but it turns out when you send it to the lab, it's not methamphetamine. The same thing applies to the marijuana / hemp issue now. We don't want to be convicting people for possession of marijuana if in fact what they possess did not have the requisite amount and type of THC in it to qualify under the statute to be criminal possession of marijuana. But roadside, the officer can only go as far as he can go. He is not the crime lab, but he can make reasonable decisions based on his observations and training as to what would conduce to being something that is against the law. And it is his duty to investigate violations of the law. I'll briefly address the second issue in regard to the court cost payments. As we noted in the brief, I can't find in the record where there was any kind of a waiver by Mr. Brown as to a hearing on inability to pay. And I suggested to the court that that be corrected by order of the court to, take that out of the judgment. And that should alleviate any issue that, we don't want Mr. Brown to be taken into the bogey for failure to pay. I believe the terms of the judgment are that he will have 6 months to pay that off, from what, we anticipate to be a mandate, prayerfully anticipate that he will have the time to pay that off, and that the issue would not be right, for determination by the court because of that. Nevertheless, we would, ask that, that provision, that waiver provision be stricken from the judgment of conviction. Any questions? Might I have just a moment to digress? Chief?
No, I don't think so. Appreciate it. No,
I've enjoyed the 10 years. Thank you for your service.
thank you. Okay, this case is submitted, oh, I'm sorry, you get rebuttal, that's right.
I get to digress.
Let me get this stopped and reset, excuse me. There you go, thank you. You may proceed when ready.
Thank you, Aaron. I just wanted to follow up on a couple things. I understand the state's opinion that the officer is on the side of the road, he has safety interests. That does not circumvent what the actual legal protections for citizens are. I understand the officer may have safety concerns, but that doesn't mean he gets to break the law. The odor of a substance can lead to a consensual encounter. That's exactly what we were talking about when he was telling the story of the DWI. If you smell something, the officer can always go up and continue a conversation. It's just whether or not he can compel someone to answer, and that's the distinction in our case. He had no right to compel Mr. Brown to give his identification because at that time, there was no reason, nothing articulated as to why the officer would assume that my client had done anything illegal specifically. Also, he talked again about.
Are you suggesting that if an officer smells marijuana, even after passage of the hemp act, that if an officer walks up to that individual and asks for their identification, we're gonna take it out of the car stop context, that person can turn and walk away from the officer and deny the officer the opportunity to investigate whether or not a crime has been committed?
I think he has the right to detain the person, but not interrogate. I know this was taken up in reference to a house case recently. I don't remember the name, but the officers smelled marijuana at the home. They were called out to home because someone said it smelled like marijuana. When the person answered the door, the officers smelled it and they burst in and arrested people without waiting for the warrant. They wandered the house. I think it can lead, if it's someone on the street, I think it can lead to a reason for an officer to maybe look for other clues, a totality of circumstances to request a warrant. But I don't think it would lead to a situation where the officer could stop and demand identification for that person. I mean, it would be if the officer came into the courtroom, you go to court, a lot of times it smells like marijuana in there. If an officer is allowed to detain and identify everyone because he just merely smells marijuana in an enclosed space, then he could stop and detain everyone in that room and force them to identify themselves, which just isn't reasonable, especially in light of the fact that there can be legal reasons for smelling like marijuana.
Okay, change my hypothetical now from encounter on the street to encounter on car side of the road, middle of the night. You've got very
Yes. And it's
limited persons involved.
And that's where we've always applied the automobile exception, where because the automobile is mobile and there's not always time for a warrant on the side of the road, on the road specifically, it had been held that the odor of marijuana could give rise to PC to search without a warrant.
But now there's a legal reason. If someone smells like alcohol on the side of the road, that doesn't automatically lead to BC. There have to be other factors. Even like the state said, glassy eyes, and slurring speech, something else. And that's all we're asking for, is that the odor alone not be enough. There has to be something else. If my client's eyes were glassy, if he was slurring, if he was slumped over, if there was a physical evidence in the vehicle that something illegal was going on, that he could tie to that smell, that's all we're asking for. Because now at the point that it is potentially illegal, the burden shouldn't be on the citizen to have to stay and be detained when they may not be breaking the law at all. And then specifically in the St. George case, it was decided in October of 2007 by the Texas Criminal Court of Appeals. Brennan had come out in January of 2007. So they had 10 months to decide whether that case was going to be applicable to St. George or not. And it wasn't. And they specifically said, in that case, there was no odor of marijuana. They just are questioning the passenger and forcing him to give identification that they don't. If you're at a stop, unless the officer can identify something specifically toward you, you do not have to identify yourself.
On your second issue, state has essentially conceded reformation of the judgment. Does that solve your issues with the second issue?
Not completely, because if we remove the waiver, which is good, the court has still ordered that my client be immediately remanded. And at this point, the court hasn't allowed or offered my client the opportunity to have a hearing that he's legally allowed to have to discuss the indigency before he's remanded. And so we would be in a situation where the court could order him straight to jail, and then we're fighting to try to get a hearing after the fact. So we would still ask that that portion of the judge's order be changed, because he had no authority to withhold a hearing for my client.
Okay, we'll look at that issue. You did, or at least as far as me looking at your brief, quickly and on the fly, I did not see where you cited to, Isaac or Scarborough. And the state did reference Blinn, but I need a supplemental brief from you by, Friday, that cites all the authority, that you cited in oral argument today that's not in your brief.
All right, Your Honor, would that be by 5 on Friday or by Friday?
I'll give you the weekend, 8 o'clock Monday morning.
Okay, thank you, Your Honor.
See, I give a little and somebody wants an answer. 8 o'clock Tuesday. All right, I tried this once before, I'll try it again. This case is submitted, y'all are excused. To the audience, normally I introduce elected officials. There weren't any this morning, but there are this afternoon. We have David Hilburn. David, raise your hand, stand up. He's a district judge here in Brazos County that actually sits in the 361st, which was the trial court that Steve was in when he was here in Brazos County. And I see to David's left is Thomas Sleeper, who, while not elected, is the city attorney for the city of Bryan. And if you did not catch the part this morning, go to the YouTube feed that explains why us being in the city of Bryan, as Thomas was able to confirm for us 2 years ago, that we are actually in the city of Bryan as we sit here now. So thank y'all very much. That concludes the 10th Court of Appeals arguments in Blinn. Thank y'all.